one of your most high-profile verdicts was not as Chief Justice, but the Ayodhya verdict. And I'm not going to discuss that verdict because I think enough has been said on it. But what I want to ask you is, in that verdict that you are widely believed to be the author of, let me ask you, were you the author of that verdict?
Barkha, I'll tell you that.
I don't know if I'm allowed to ask that, but I'm just, because it was a verdict without a byline.
But Barkha, we all decided that the entire bench of 5 judges would speak with one voice.
But did you author it?
Therefore, there would be no attribution of authorship.
Okay.
You
decided to be like The Economist, basically, and have no byline on that particular
we
verdict.
decided that because this was an issue which was fraught, which had divided the polity, it had a history of conflict. Therefore, all of us must speak with one voice. Now, that being the decision of the Constitution bench, headed by the then Chief Justice, I stand by that because I'm party to the bench.
Of course.
And to now say that, well, who actually wrote the judgment would in that sense be unfair because, we all decided to speak.
That was a sidebar question. The question really is about what the verdict says about the Places of Worship Act. So if one reads the Ayodhya verdict, as I have attempted to do, the verdict is very clear in emphasizing A, the exceptionalism of this verdict, and B, talking about the importance of the Places of Worship Act and locating it within the basic structure of the Constitution. Now, what I'm leading to is perhaps one of the most debated responses by you as Chief Justice was your response to the Gyanvapi survey. And you're saying in open court that while the Places of Worship Act put a freeze on changing the religious characterization of a place of worship, it did not actually forbid the survey from happening, from ascertaining, where was this a mosque or was this a temple at one point of time. Many people believe that that observation itself opened the floodgates, sent a message down to smaller courts, led to the situation that we saw in Sambal. And the Supreme Court has now halted it and said, look, we've got to decide this matter. When you look back at that moment, do you regret that comment that you made in open court that kind of became a template for how this debate is now unfolding? Do you believe that you should have halted the Gyanvapi survey?
Barkha, when the Gyanvapi case came up before the trial court ordered the survey. The High Court affirmed the view of the trial court. The case came up before the Supreme Court. The survey had been completed. In the Supreme Court, contrary to something which is again not highlighted adequately in the press or in the media, we made sure of 2 things. First and foremost, that the worship in the Gyanvapi mosque, namaz, must be allowed to continue as before. We issued strict directions to the collector and district magistrate of Varanasi to ensure that worship in the mosque is not impeded in any manner, including the antecedent places like the wuzu, where the other rituals are done in the mosque. That was one aspect. We prevented the carbon dating of the particular site where the plaintiff's claim was really the structure of religious worship. So we stayed the direction for carbon dating because we said this must await the evidentiary trial in the course of the proceedings. And since worship was going on in the cellar, we allowed the worship in the cellar to take place by the Hindus so that a degree of balance was maintained. We allowed worship in the mosque. We have allowed worship in a cellar where the points of access are completely different to obviate any controversy.
So you maintain status quo.
So exactly. And we have maintained the degree of balance. Now, maintaining this degree of balance is crucial to preserving the character and fabric of our society. That's one aspect. The second, which I want to tell you about, is that, Ayodhya dealt with an exception. Section 5 of the Places of Worship Act says that nothing in the Act will apply to the site which is called as the Ram Janmabhoomi Babri Masjid site. That's the way the 1991 Act refers to it. And therefore, it creates a specific exception in regard to Ayodhya.
Yeah.
So there was absolutely no dispute that the suits in Ayodhya would have to proceed, because that's what the Act itself says. Now, coming back to your question, during the course of an argument in a court, there's a free-flowing dialogue between judges and lawyers. I asked a question in the court, in the Gyanvapi dispute. I asked a question in the court. The case is still pending before the court. We have not passed an interim order, right, by virtue of which we have actually given vent to that question. Yeah. That question remained a question. If you prevent judges from discussing issues which arise in the context of a case, I think that will be all to the detriment of the cause of justice, because you must allow this free-flowing dialogue between the court and the lawyers. Now, coming to the Place of Worship Act, what does the Place of Worship Act do? I'm not going to comment on the merits, because let the Supreme Court decide that. But I must tell you, because it's very important.
Yeah.
The first part of the Places of Worship Act says that the religious character of a place, no person shall convert the religious character of a place from one religious denomination to another. That's the first part of the Act, Section 3. The second part of the statute, Section 4, says that the religious character of a place as on the 15th of August 1947 shall be maintained as it is. I'm placing it in very simple terms. That's the second part, Section 4. Now, Section 4 has itself an exemption. Section 4 says that nothing contained in subsection 1 or subsection 2, that is, nothing contained in the previous provisions of the section, shall apply to any structure of historical or archaeological significance. Right? So that what the Act does on the one hand is, though it maintains the status quo insofar as the religious character of a place is concerned, the Act itself has an exception in regard to structures of historical or archaeological significance. And then finally, Section 5 creates an eo nomine, as we say, a named exemption in favor of the Ayodhya dispute, because suits had already been filed and suits were pending. Section 4 also says that any suit which has been filed will abate and no new suit will be filed. But then comes the exemption. The question which I asked was therefore this: once the statute, the Places of Worship Act of 1991, itself contains an exemption in regard to places of historical or archaeological importance, which means essentially a monument which is more than 100 years old, because that's the Archaeological Sites and Remains Act and Monuments Acts of 1958, which puts this benchmark of 100 years. Would a survey to determine whether it falls within the exemption be barred? That's the issue which is to be decided by the Supreme Court. That's the question which I posed. If I didn't pose the question, obviously, I would be not raising a fundamental issue. Now, if a judge raises an issue which squarely arises from the text of a statute, is that in itself wrong? I mean, you have to have that discourse in a court. That's the distinction between the world of politics on the ground and a court. In a court, there is a reasoned dialogue. You're unraveling, I may be right, I may be wrong. A lawyer is entitled to say, no, judge, your prima facie question, I have a different view for this particular reason. A lawyer is entitled to say that. The other side is entitled to say, no, I maintain that, this is the correct interpretation. It's out of this conflict, not conflict in a sense of conflict, but this opposition between two divergent voices in court, that a synthesis emerges.
I understand, but sometimes there are consequences to a judgment. You or any other judge is doing the best that they have estimated in that context, applying the law. And then you see something like a Sambhal flare up, and you perhaps pause and you say, okay, could I have done this differently? I know it's not an easy job, and these are very, very complex decisions. It's like people ask journalists all the time, oh, you did this and this was the consequence of your story. And I always say, well, we had to be true to the story in that moment. We can't control the consequences. But I'm just wondering how you think about the consequences.
Barkha, the consequences. I mean, consequences have to be handled by the executive,
right,
by the law enforcement machinery,
right,
to preserve peace. We have to apply the law as it appears to us correct as judges. And the duty of every court is to apply the law as it appears, or as it has been enacted.
Yeah.
The preservation of peace within society is a broader function of civil society and the constitutional authorities which are entrusted with the duty to maintain peace, law and order. But surely, asking a question in a court cannot be targeted as something amounting to a final expression of opinion, or something which has caused a wider sense of disquiet. In fact, if you look at the orders which have been passed in Gyanvapi by the Supreme Court has ensured that a degree of balance is preserved. And that balance, to my mind, in a multi-religious society is crucial. You have to preserve the balance between all faiths. We can't not look at the faiths of a cross-section of our society. And we've tried to do that. And ultimately, the test is the status quo which is continuing in the Gyanvapi area itself.